A judge threatens contempt of court charges after an altercation breaks out in a gallery inside of a courtroom. Welcome back to Court TV Live. I'm Julia Janae. We'll get you into that courtroom in just a moment. We are following things in Wisconsin where sentencing is underway for Parise Larry in the Caught in the Crossfire trial. Back in October, a jury convicted the 16-year-old of first-degree intentional homicide in the 2023 death of 20-year-old Tatyanna Zech. Now, Larry, who was actually 14 when this incident happened, and his friend Antonio Johnston, they reportedly had some kind of beef with another teen and then began shooting at that teen in an apartment complex. That shootout was captured on surveillance video. Tatyanna was caught in the crossfire. We want to get you back inside of that courtroom now. The judge has been addressing everyone after that altercation. This is hours after it happened, and they are starting things back up with the arguments over what the sentencing should be.
May impact is whether or not people seated in this gallery are allowed to continue here or whether they face findings for contempt. Because everyone that's seated in the back, you are responsible for your own choices as well. I hope you make better ones than you made this morning. Attorney Tony, are you prepared to pick up where you left off?
I am, Your Honor. Thank you.
Go ahead.
Your Honor, to assist the state with picking up where I left off, I did confer with the clerk just to get a few, essentially an idea of where the argument was when we had to break because of what's already been outlined. And just as a brief summary, the state had gone through the general sentencing factors, the conduct reports of the defendant while in custody, the videos with the gun, and then was discussing the bullets and fragments that were recovered from the investigation, and that's essentially when the sentencing argument stopped given the circumstances. So I'll pick up from that point. And so essentially we have a number, 13 rounds that were fired by a combination of this defendant, Mr. Johnston, and then one more by one of the victims. And in the rounds that were recovered, the crime lab analyst testified that based on the condition of the rounds, the markings that were available on the bullets and fragments, none of those bullets were able to be matched to the firearm that had this defendant's DNA on it or the firearm that had Mr. Johnston's DNA on it based on essentially the condition of the bullets. So based on that, the state and nobody is able to say which one of the defendant's bullet was the one that hit Tatyanna, Javier, and Keyshawn, and so we're just not able to do that based on the forensic evidence that's available. And the testimony at trial reflected based on, I think it was Detective Mylon and Detective McCulloch's work, that based on the door, the angles, that it could have been either one of the defendant's bullets that hit Tatyanna or any of the other areas. And so we certainly understand, given the number of rounds that were fired by the co-defendant Antonio Johnston, that some of his bullets had to have caused some of that damage, just given the number of rounds, and that some of those could not have been caused by this defendant, given the two that could have caused that damage. But it is within the possibility that his bullet was the one that hit Tatyanna and took her life. And so, in looking at some of the other factors the PSI discussed, and I kind of touched on these a little bit, of the support that the defendant had, and his father is in federal prison in Indiana right now and hasn't seen him since he was about 11 years old. He had other family that was around helping him grow up, and there's the support, as noted, that's been in the courtroom for him that we don't always see. The PSI and some of the other evidence that came out at trial, the defendant had the IEP while in school that seemed to relate to some of the anger type issues. There wasn't a specific mental health or diagnosis that was noted. Counsel shared I think it was depression and anxiety that they noted their client may be experiencing, but there was no diagnosis or some type of mental health concern that had the defendant in that type of schooling. It was more of some of the anger issues that seemed to lead to that based on my review of the PSI. The report also discussed some of the substance abuse issues that the defendant has, and goes through some alcohol use, but it appeared less often. More significantly was the daily use of marijuana, ecstasy 4 to 6 days per week and codeine on a daily basis, and then some others that were of less, including benzodiazepine. And so there were and are substance abuse issues for the defendant, but when we look at the facts and evidence that's available in that which was presented at trial, there was no indication that the crimes themselves were the result of drug or alcohol use from this defendant, other than we know Mr. Johnston was rolling marijuana in the hallway at the time, but it didn't seem to be an issue over drug use, drug dealing, or under the influence of some type of alcohol or drug that led to the offense based on the ultimate circumstances. When we look at the defendant's conduct, fleeing the scene, disposing of the firearm, fleeing the state, as was noted in trial, he did voluntarily turn himself in at a later time to law enforcement. And the court has already, I think, hit on this. We have numerous families that are broken, devastated, and will be impacted for the rest of their lives because of the actions of this defendant. And the PSI noted that he was born in Chicago, and I think it was around 4 or 5 years old, moved to Milwaukee, and then his family found his way to Fond du Lac. And one of the things we know is some of those areas and neighborhoods in Milwaukee and Chicago are not the safe of some of the neighborhoods that we have here in Fond du Lac. And it was something the state noted, I think, in its closing argument at trial, that if some of these folks may have been born in Fond du Lac, they might not be in the situation they're in based on the environment that they may have been raised and grown up in. And ultimately, though, we know this defendant had support, he had family, he had those that care about him, that gave him an opportunity to not go down the path that the defendant ultimately went down. And we certainly know, and the defense argument in their brief, or sentencing memo, I should say, touched on juveniles, brain development, things of that nature, which the court certainly needs to consider when imposing a sentence for this defendant based on the nature of the charges. And there's nothing in the record that shows the defendant was unable to understand what he was doing was wrong, that he shouldn't be doing it, that it was just a singular moment. This was the behavior and activity that the defendant ultimately was engaged in. And we've seen other studies that show with juveniles, when it's not enough for them to know that there are serious consequences. That doesn't deter a juvenile from committing a crime. What deters them from committing a crime is believing that those consequences will be enforced, that has the impact of deterring a juvenile from committing those types of crimes. And one of the cases that the state reviewed, State versus Ninham, Ninham 333 West 2nd 335, a 2011 Wisconsin Supreme Court case. And in that circumstance, the court did not find, well, say it this way, that the court can sentence a juvenile to life without parole if the court takes into consideration the various factors and what the, I'll say, societal norms may be at the time. And in 2011, the court noted that there were, in the United States at that time, 73 juveniles in the country that were 14 or under that had been sentenced to life without parole. And what they noted is the rarity of it did not make it a national consensus. And they also noted it's the rarity of a juvenile at that age of 14 that commits that type of crime. And sometimes a lot can change in 15 years, and one of those unfortunate changes is that we're seeing more and more juveniles committing significant crimes in our community. Not always to the level of an intentional homicide. Thankfully, that still remains incredibly rare, but we are seeing that increase in crime from juveniles or young adults that drive some of the significant crime in our community and other places. And so ultimately, it comes down to what is the appropriate sentence in a circumstance like this, the rare circumstances like this. And as I noted earlier, we're not just here for the death of Tatyanna, but the others that were impacted by the defendant's decisions and the defendant's actions. And so what I'm going to do, Your Honor, is walk through what the state's sentencing recommendation is and explain essentially why we're making this recommendation, which there's going to be a recommendation of some counts running consecutive to each other, but then concurrent to other charges. And doing that so that each and every one of the victims will have a significant amount of confinement time for this defendant for the crimes that have been committed against them, as opposed to just running everything consecutive to each other and having some smaller chunks in there. And so what I will do is essentially start backwards at count 17 and work my way forwards, because I believe that will make it a little easier. And so on count 17, the child in possession of a dangerous weapon, the state is asking the court to impose 9 months jail. And on counts 12, 14, 15, and 16, the reckless endangering safety counts, those 4 counts, the state is asking the court to impose 10 years of initial confinement and 5 years of extended supervision on each count. And on count 11, the first-degree reckless injury, the state is asking the court to impose 20 years of initial confinement and 10 years of extended supervision. That would be a total of, and we're asking that those counts, 11, 12, 14, 15, 16, and 17, run consecutive to each other. That would total 60 years of initial confinement and 30 years of extended supervision. What I'm asking the court to do, the state's recommending on the attempted homicide count, factoring in the sentencing enhancers, that the court impose a sentence of 50 years of initial confinement and 20 years of extended supervision, that count 10 be concurrent to counts 11, 12, 14, 15, 16, and 17. And then we're asking that those counts be concurrent to count 9. And on count 9, the state is asking that the court find the defendant the life sentence without the eligibility for supervision. If the court would believe that supervision be appropriate, that it do so no sooner than 60 years, which factors in the sentencing structure that the state has recommended. We don't come to that recommendation lightly. Given the circumstances here, we're not talking about, as I've noted, just one homicide. We're talking about the others that were shot, the danger to the community, all of those circumstances that lead up to this, that puts this in that rare circumstance where life without the opportunity for release becomes appropriate. I think the conduct of
the prosecution there asking for life without parole for the defendant, who was 14 years old when this happened. But they said if there is any chance for parole, they ask that it happen not until 60 years of confinement. We do have to get to a break. We do also want to give you an update out of Providence, Rhode Island, where that manhunt had been underway in the Brown University shooting, but that is now over.
That individual was identified as Claudio Neves Valenti. Date of birth, and he was a 48-year-old man. He was a Brown student. He was a Portuguese national, and his last known address was in Miami, Florida. And I will tell you that he took his own life tonight.
And that was from the press conference yesterday evening. We are now getting word that they believe now that he took his own life on the same day that the MIT professor died in Massachusetts. They announced that they found this suspect, Claudio Valenti, dead in a storage unit in New Hampshire with a self-inflicted gunshot wound. And that autopsy determined he had been dead for 2 days. The gunman opened fire Saturday, killing 2 students and wounding 9 others on the Brown University Ivy League campus. Valenti also is suspected of killing an MIT professor in Brookline, Massachusetts, days after the Brown shooting on Monday. Officials said it appears that the men attended the same university in Portugal. We will continue to keep a close eye on that case and bring you updates throughout the day right here on Court TV. When we come back, we will go back into that courtroom for the Larry Parise sentencing hearing. It's a caught in the crossfire trial as the defense attorney pleads his case for leniency. Keep it here on your front row seat to justice.
A brutal killing sent shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation
their own son charged with their murders.
as a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
Welcome back to Court TV Live. Let's get you back inside of the Wisconsin courtroom where we are watching together a sentencing hearing that's going on for a convicted teen killer. This is Parise Larry. His attorney asking this court, or first we're going to hear the rest of what the state has to say, and then his attorney asking for something less than life without parole.
Defendant, while in jail, what was observed during trial at this stage shows a defendant that has not shown remorse, and he will have the opportunity to address the court later. Perhaps he will at that time exhibit some level of remorse, but that just has not been seen up and until this point. And I agree with the court that the defendant did not seem to have any role in what occurred earlier this morning. The state does not take that into account or in any way modify its recommendation based on what occurred this morning, but the state is asking the court to impose that sentence after careful consideration of the factors the court must consider, factoring in the defendant's age as well as the overall circumstances, and asking the court to adopt their recommendation. Thank you.
Thank you, Attorney Tony. And just to be clear so that I'm understanding your recommendation appropriately, as it relates to all of the counts, you are asking that all run concurrent to count 9, correct?
Correct. And I think I did misspeak in just the overall. It would be on counts 11 through 17, it would be 60 years and 9 months. I missed the 9 months on the misdemeanor.
All right. So you're asking for 11, 12, 14, 15, 16, and 17, all to be consecutive to each other. Count 10 to be concurrent to everything, and count 9 concurrent, or everything concurrent to count 9.
Yes, that's another way of saying it. Yes, thank you.
All right. Thank you, Attorney Tony. Who's going to be taking the lead for Mr. Larry?
I will, Judge.
Okay, go ahead.
Judge, as you can imagine, we've thought a lot about what to say on behalf of Parise, and what I was originally planning on saying changed as recently as yesterday. I have a son who in 12 days will be 14 years old and 7 months. And at his school yesterday, and I believe it's the #1 public school in the state, a student made a threat about a gun. There was a lockdown, and everybody was okay. But children everywhere in this country have access to guns. Even kids in the most affluent communities. And I bring that up because in my memorandum, about the actuarial table, about who's going to end up in prison in our country. And my son didn't grow up in poverty. Parise has. When I look at family composition, even in my extended family, there is not a single parent. There is nobody with any substance abuse problems. There's nobody in prison. Nobody has had a parent who's abandoned them. They all have health care. If they do have any developmental issues in school, they're taken care of. And we do know from Dr. Collins that Parise does have some developmental issues. And while he is at the time he was 14 years old and 7 months, he was not intellectually functioning at that level. He wasn't even close. That is what a professional evaluated him at. Again, nobody in my family suffers from abuse or neglect that I know of that's fueled by poverty. As I said, I know the school that my son goes to is excellent. And so when we look at what are being said, the choice that Parise made, and it was a horrible choice, some of the choices that we make are forced upon us by what...
A really personal sharing from this defense attorney in starting his plea in front of the judge. Let's get some analysis of it from our criminal defense attorney that's standing by. We have former assistant prosecutor attorney Franz Borghardt with us. Franz, good to see you on this Friday. Let me know how you think the defense is starting out. This is a strategy. We sometimes see defense attorneys use it where they talk about their own lives, their own children, their own situation, and comparing it to their client.
I don't mind a personal strategy. What I'm cautious about is using the defense of this is a socioeconomically disadvantaged young man. And in some respects, that's why he did what he did and is about to land in jail for possibly a life sentence versus my son who's not disadvantaged. That is a very dangerous argument because there are a lot of disadvantaged, socioeconomically disadvantaged children or young people who don't commit this crime. So that is just tricky. It's a tricky argument. Now, what I do like is he is 14 at the time of the crime. He is not fully developed. This is a young man who, after 20 or 30 years of incarceration, will be literally a different human being. That's the better argument in these kind of situations where we have a juvenile defender tried as an adult who is looking at a life sentence, and you're arguing, if you're lobbying, you're mitigating for parole.
Yeah, life without parole is what the prosecution is asking for here. Are you surprised because of the age? I mean, without anything else, but I do think the developmental issues that the defense is trying to lodge, it's often difficult for these attorneys to really get in the breadth of it in front of the judge. But there was testimony and there was this understanding, perhaps even from him on the stand, talking that this judge may understand that there are some delays there. But the prosecution not budging on that without parole element.
Not just 60 years life without parole, but make sure you don't forget about the 9 months too. I'm not surprised they're asking for that, and it may in fact be the right thing to ask for in this case. You know, I've seen prosecutors in these kind of situations defer to the court. I've seen them lobby for life without parole. It's all over the spectrum. So I'm not shocked that they're doing it, but there are certainly mitigators in this case. There's certainly mitigators in this case with regard to his development that might lend itself to a court saying, you know what, we're going to give him parole way down the road after he serves a lengthy sentence so as to give him that possibility. And just because he has parole eligibility doesn't mean he automatically gets out.
Yeah, absolutely true. But after 60 years, he'll be considerably older. Let's get to our break, Franz. Stand by. We're going to continue to listen to perhaps even how this judge is responding to see if that gives any suggestions to how she's going to lean in this. Here's a look also at the other trials that we're keeping our eye on here at Court TV. In Utah, there's a woman who confessed to murdering her parents and trying to kill her brother. She was sentenced today. Mia Bailey is going to serve 25 years to life in prison. That was the finding today. And in New York, a retired Army veteran and former state trooper has pleaded not guilty in the 1997 killing of a woman whose remains were found near the victims of a Long Island infamous Gilgo Beach killings. Andrew Dykes is charged with second-degree murder in the killing of Tanya Denise Jackson. Also in Ohio, a man whose trial was set to get underway today on charges that he shot and killed a mother of 3 pleaded guilty just before opening statements began. In a plea agreement, Zachary Gilbert pleaded guilty to the lesser charge of involuntary manslaughter. This is in the shooting death of his on-again, off-again girlfriend, Brianne Otley. We'll get you back inside of the courtroom there in Wisconsin for the Parise Larry sentencing after this. Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us. We are continuing our coverage in the caught in the crossfire sentencing of 16-year-old Parise Larry. He was convicted of killing 20-year-old Tatyanna Zech and wounding 3 other people back in May of 2023. He was only 14 years old at the time of this incident. We want to get you back inside of that sentencing hearing where his defense is addressing the judge, saying that he doesn't deserve life without parole.
By what our circumstances are. So the choices that Parise had an opportunity to make, my son would never have the opportunity to make. There would be nobody handing out guns to my son that I'm aware of. There wouldn't be anybody handing out a variety of drugs to my son that I'm aware of at an age younger from when Parise started taking drugs. It's not to say there aren't drugs throughout high schools. So when we're looking at where Parise ended up, studies show this is where young men with these types of life circumstances end up. And it's not fair, and it's not right, and it's obviously not fair and right what happened to the victims here. But when we are judging people, we should make sure that we're not judging them from our point of view. And so when we take somebody and we bring them into adult court, because that's what the state of Wisconsin has decided that we do, we engage in a kind of fiction, saying, because your choice was so bad, we're going to treat you as an adult. But we're not going to allow you to make other choices. You can't get married. You can't enlist in the Army. You can't gamble. You can't use a tobacco product. You can't make healthcare decisions for yourself. But we're going to put you in a courtroom, and there's going to be a point, if you have a trial, where you're going to have to make a decision that is so difficult, adults have a hard time making it. And it's whether you should testify or not, and whether you should plead guilty. That's an incredibly hard decision for an adult, let alone a kid like Parise. And so when Parise was in a situation on May 7th where gunfire broke out, he did make choices. And some of the choices he made are explained by him being a juvenile. And the science supports it. And when we're in court, there can be a big disconnect between there is the emotional context that we all feel and really human behavior. And while we all dream that people will always behave in the right way under stressful circumstances, it's not realistic, it's not based in science, and it's certainly not based how we would expect a 14-year-old to really ever behave in high-stress situations or dangerous situations. And that's why we also, in the state of Wisconsin, recognize the things that we just won't allow them to do. I mean, Parise wasn't even eligible to drive a car. That was a year and a half off, and that would have been after training. And I know Parise has remorse. I'm pretty sure the court saw him crying in court today when both sides were talking. And what really struck me the other day when we went over the PSI was when he started talking about his grandmother. And he said how much she means to him. And I said, well, you know, Parise, what has she said to you about this? Well, we haven't told her. She's real sick. It would make it worser for her. So he knows that his actions are definitely affecting and having a ripple effect on his side of the family. He also knows that he was convicted of taking somebody's life. And he definitely doesn't feel good about that either, and realizes there is nothing he can do to take it back. But, you know, as I said, it took almost 15 years for Parise to get here.
The defense attorney has pivoted there in his statements to the judge, away from his own personal stories and now to those stories about Parise Larry. And that one about the grandmother might be something that resonates with this judge, that this grandmother hasn't even been told about it. Someone who could potentially be giving emotional support to the defendant doesn't even know about what he's been going through the last 2 years. We have to get to a break, but first we do want to share some developments out of Washington in the Jeffrey Epstein investigation. Late this afternoon, the Justice Department has officially started releasing long-awaited records from that case. There was a deadline for today, and that document drop began today under a new law that was passed by Congress, though officials won't say, though, it won't all come out at once. So it is not a complete document dump today. The Justice Department expects to publish hundreds of thousands of pages, with more to come in the following weeks. The documents include photos, call logs, interview transcripts, and grand jury material tied to the nearly 2 decades investigation into Epstein's sexual abuse of young women and underage girls. But it is still unclear how much new information the public will actually learn, because already much of it is redacted. We'll keep you updated on any developments there. When we come back from this break, we'll get you back into that Wisconsin courtroom for the caught in the crossfire sentencing for Parise Larry. Stay with us.
Brutal killings send shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation
Their own son charged with their murders.
as a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
Giving.
Welcome back to Court TV Live. We do want to get you right back inside of the Wisconsin courtroom where we are watching the crossfire sentencing, caught in the crossfire sentencing, rather, of Parise Larry. Now, earlier in this case, we heard today the judge having to admonish the gallery because there was a brawl that broke out. Hours later, everyone got back into that courtroom and she gave them the orders to act right. And now we're about to see her have to admonish someone else again.
So, if it took him 15 years to get here, and we can predict that he would get here, I don't know how it's possible to lock him up for the rest of his life. So, the real question is, how long should it take him to go to prison and come back to society? And that's a hard thing to put a number on. I know the court's aware that we've asked that he be found eligible at 20 years and all those other counts run concurrent. And we don't make that lightly either. But when you think about the changes that can happen in a young man's life from 14 to 34, that's a time when you've probably given up your childish ways, hopefully, where you have graduated from high school, possibly graduated from college, started your career, started a family, maybe bought a house. Because really, the only thing that would happen in this case if Parise were locked up would be punishment. There would be no rehabilitative goals whatsoever. And as I read from United States versus Carvajal, rehabilitation is also a goal of punishment. The goal cannot be served if a defendant can look forward to nothing beyond imprisonment. Hope is the necessary condition of mankind. For we are all created in the image of God. A judge should be hesitant before sentencing so severely that he or she destroys all hope and takes away all possibility of useful life. Punishment should...
Pause. He cannot come back in the courtroom. I just had a phone ring in the courtroom despite all of the warnings I gave earlier. Now Attorney Mogren's sentencing argument's been interrupted. I caution anyone, if you have your phone, turn it off, put it away, or you will not be allowed back in this courtroom either. Attorney Mogren, I apologize for having that interruption. Go ahead and continue, please.
Punishment should not be more severe than that necessary to satisfy the goals of punishment. Judge, I'd just like to add a few other things. You know, during the 2 weeks of trial, I sat next to Parise the whole time. I think you're aware of that. And he had a pad of paper in front of him. And he would write. Sometimes he would be distracted. And I'm not surprised, given his diagnosis, given everything else. But that was, when I thought about it, the sitting in the courtroom for 2 weeks and being quiet and probably having his own thoughts, that's probably the only time, even in this high stress situation, that he had that time to just sit and really be within his own thoughts that he's ever had in his whole life. And how sad is that? That the safest, quietest environment he's ever been in is in the middle of a homicide trial. So it's not that I'm saying Parise shouldn't be punished, but Parise's life, compared to most of ours, he's had unearned disadvantages that most of us can't fathom.
We are approaching the top of the hour. Let's bring back in criminal defense attorney and former assistant prosecutor Franz Bornhardt to discuss what we have seen so far from this defense. And we heard the ask there, Franz, for parole after 20 years, meaning not that he's necessarily going to get out, but he will have the option to go before a parole board at 20 years. You're already shaking your head. What do you think?
I think sometimes as a defense attorney, I ask for things I know they're going to say no for, like 20 years parole eligibility, hoping that I get like 40. So I don't mind the bad ask. I call it a bad ask because I think that that was strategic. Now, it's always possible the judge may say yes to that. I just don't think that that's realistic. I think that parole eligibility for this case has to be more akin to 30, 40 years if he's going to grant it. Best argument I've heard from this defense attorney in the argument was about this is someone that we create a fiction for to try as an adult, and talked about all the things he is not developmentally allowed to do as a juvenile by law, but yet we're trying him as an adult. I thought that was a wonderful argument. I thought the bad argument, the argument that makes me again uncomfortable is, well, he's disadvantaged, and that's why we need to cut him a break. Well, the problem again is there are a lot of disadvantaged folks that are not going around killing people, and if you're a judge, that is generally the knee-jerk reaction.
That's true. The things that he's saying, they're not untrue in terms of the opportunities that perhaps his own son had that Parise Larry did not have. So that could resonate with this judge, but you don't want to paint with a broad brush. You don't want to make it seem like this is the reason that he became a killer. And I don't know how the judge is going to go in this. I feel like she is definitely being very cautious to make sure she lets everyone know she's being balanced in this, just in how she addressed the gallery when she was upset with both sides. The family members of the victim here and the people who are there supporting the defendant. She was not happy about that phone going off. What do you think about sometimes when victims are in the courtroom and they're passionate against the defendant, but that may not help what they want, which is to get a stiff punishment here?
So earlier we heard that she did not want the record to reflect that she was going to hold any of this against the defendant. And I think that what this will do in this case, especially the phone going off in the middle of his argument, which by the way, come on, turn the cell phone off. At this point, your cell phone being on and it going off during the argument is really unexcusable. I think that subconsciously that can't help but benefit the defendant sitting there, whether the judge is actively thinking about it or not, and that may go against the victims.
Yeah, it really may. Franz Bornhardt, thanks so much for your analysis this hour. We always appreciate it. We do have to get to our break. When we come back, we'll get you back into that Wisconsin courtroom, more of the caught in the crossfire sentencing, and we're going to hear this defendant address the court. Is it going to impact the judge at all? And those victim impact statements that we heard earlier, how is that all going to affect the judge's decision? We're going to watch it together next.
Org today.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this evening. Before we get you back into the courtroom in Wisconsin, let's take a look at the cases we are tracking here at Court TV. Some developments today. In Ohio, it took nearly 3 hours of deliberations before a jury there found Paul Hicks guilty of kidnapping and killing his estranged wife, Regina Hicks. And this would have happened back in 2001. Her body was found inside of her vehicle in a pond, and he now faces up to life in prison when he is sentenced on January 9th. And in Wisconsin, the case against the defendants in the child starvation case will go to trial. Savannah Lefevre was in court today and waived her preliminary hearing, and the judge bound the case over to criminal court. Lefevre and her 3 family members are charged with child neglect for allegedly starving a 14-year-old who has not been identified in their care. And in Utah, accused Charlie Kirk assassin Tyler Robinson wants the Utah County Attorney's Office removed from the case. The defense claims one of the attorneys has, quote, personal connections to a witness to the shooting. Robinson is charged with aggravated murder in the September 10th shooting of conservative activist Charlie Kirk. Kirk was speaking at a political event in Utah Valley University when he was killed. For now, let's head back to Wisconsin for the sentencing of 16-year-old Parise Larry, who was convicted of murder. He was 14 at the time that his gunfire, along with his co-defendants, shot and killed 20-year-old Tatyanna Zech. She and a group of friends had gone out that day to take the trash out at her apartment complex back in May of 2023, and when they returned, they found themselves in the midst of a shootout. Prosecutors say Larry and his friend Antonio Johnston were targeting another teen that they had issues with, and Zech ended up being shot. 3 people were also wounded, and that shooting was captured on surveillance video. At one point, you can even see a young child racing away on his scooter as the shooting started. We want to get you back into court now. This is after the conviction, after the jury has spoken. It's now in the hands of a judge. The sentencing hearing continues, and the defendant is now addressing the court.
So he does need rehabilitation, but as Emerson said, the surest poison is time. So with that, I'd ask the court to follow my recommendation. I do believe Parise would like to make a statement to the court.
I will turn to Mr. Larry in a moment. I do want to make sure that I'm accurately understanding your recommendation as well. On count 9, you're recommending life with eligibility for extended supervision after 20 years. On count 10, you're asking for initial confinement of a period of no longer than 20 years, standing silent as to any extended supervision to be run concurrent with count 9, and then standing silent essentially as to counts 11, 12, 14, 15, 16, and 17, but asking that they be run concurrently.
Correct.
And before I turn to Mr. Larry, I do have a few follow-up questions, Attorney Mogren. In particular, it references some of the things that you've brought to the court's attention today. It was in your sentencing memorandum as well. Looking at page 2, right, you cite these factors from your cradle to prison pipeline citation, and you've mentioned those. You ended by talking about these unearned disadvantages. Some of that I see. I'd like you to articulate what you believe some of those to be, because there certainly were more generalities, I think, referenced in the sentencing memorandum, and taking the position that while Mr. Larry and his statements in the PSI are referencing that he's had a good life until now, doesn't recognize what some of those things are. But in looking at the factors that you set forth, I'm not certain it matches up, at least with the information that was provided in the pre-sentence investigation. I was not aware of any financial circumstances that were troublesome for the family. It was noted the opposite in the pre-sentence investigation. I'm not aware of any prior juvenile history. Obviously, there's an open matter now that I'm aware of, but there was no prior criminal history, no prior juvenile history. It referenced not any significant involvement of any Department of Human Services or Social Services, no CHIPS matters or anything like that. I think it referenced that there was not any particular neglect or sexual exploitation. There was a significant discussion of drug use and abuse by Mr. Larry at a very young age. And certainly his struggles with school were referenced. But what other things, from a factual perspective, are different? Because looking at what you've outlined and looking at the information shared in the PSI, they don't appear to always line up. So what circumstances do you believe were different for Mr. Larry, or do you believe support your argument, aside from the general statement that he's had these disadvantages? What specifically?
Well, Judge, he comes from, his father's been in prison. He has, I believe his family received some type of government benefits. So he has come from poverty. His father's in prison. I think, I don't want to misspeak, I think he has 6 other siblings. And those relationships, I believe he also said he was raised by 3 uncles primarily. All, I believe, also have criminal records. And Judge, when we talk about maybe he wasn't in foster care placement, but his grandmother helped raise him, his uncles helped raise him. So while there may not be a formal record of that type of neglect, it does suggest that there is not a natural support system that took Parise and raised him as he would in a stable nuclear family. I wouldn't say there was poor school quality. I can't speak to the Fond du Lac school system, but I know he wasn't reading at grade level. I know he had suspensions, and I know it was attributed that he was in that classroom because of behavioral issues, but behavioral issues a lot of times go hand in hand with intellectual issues. And he wasn't just in that classroom. He didn't just have an IEP because he couldn't behave. He had an IEP because he was significantly below grade level. And it appears that there is to a mental health intervention. He was taking medication for ADHD. It doesn't appear that he was having any kind of behavioral or cognitive therapy to go along with that. And Judge, I've accept, and this is completely anecdotal now, even in cases where I've had clients who've been victims of child abuse, I have almost never heard someone Parise's age say, oh, I didn't have a good childhood. They don't know better. It's literally not knowing better, because the environment he's in, he thinks it's a great childhood. It's great that I'm running around. It's great that older people are giving me drugs. I get to hang out. It's great that they're supplying me with guns. It's great that I get to, play video games all day unsupervised. I mean, that's a recipe for disaster. And that is the part that I think is reflected correctly in the PSI. And frankly, I wasn't going to talk about this at all, but the PSI writer, to say she noticed that he has no mental health issues, that there's nothing wrong with him. Mr. Jensen and I have been with him for almost 2 years now. Parise with us It takes explaining. These are not simple concepts. I'm not sure if he always understands them now. But to walk in maybe a 2-hour interview and think you're going to find out everything about Parise Larry's life and say, oh, I think he understands everything, and then recommend that a 15-year-old go away for the rest of his life? To me, that seems inappropriate. Is there anything else Your Honor would like me to follow up on?
No, that was it. Thank you. All right, then, Mr. Larry, if you wish to have me consider anything else, now is your opportunity. And just try to use that microphone so we can hear you, okay?
Yeah. I want to start off by saying I'm sorry to the victims, family, and the cause of their death of their family member. I'm sorry for all my actions that took in this place and in this courtroom. I don't really know what to say. I done lost a lot of my family members in crossfire, so I know how I feel, and I'm gonna take responsibility for everything that's in this case. And I just want to say sorry to my family and to their family. Hope everybody could forgive me or what my actions took. And that's it.
Larry. I'm going to pause a minute. This is not an opportunity to engage in discussion. It's not an opportunity to talk amongst yourselves. Please stay silent. I'm doing this so that I can gather my own thoughts, look at the notes that I've prepared in reviewing the materials that are before the court and the comments that have been made before the court today. So I don't want to fall back into the circumstances that we faced before the break. So please just take a moment of silence while the court's up here continuing to work.
All right, as the judge takes a moment to gather her thoughts, we are going to take this time to take a break, and when we come back, the judge is going to begin her sentencing. Stay with us. You're watching Court TV, your front row seat to justice.
A brutal killing sent shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation
Their own son charged with their murders.
as a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
We are resuming our coverage in Wisconsin in the caught in the crossfire murder trial that ended in a conviction, and we are now in the sentencing for Parise Larry. Let's get you inside of the courtroom where the judge is ready to give her sentence to this defendant.
Let me start by just referencing, I know Attorney Tony had touched on these. Attorney Mogren addressed all of them without specifically calling out these factors. But I do think it makes sense for Mr. Larry, certainly for you, sir, and for anybody else that is looking at wondering what's going through the court's head. What are the things that I need to look at? What are the things that I need to consider? Oftentimes we refer to them as galleon factors after specific case law. You break it down to three things. It's many more things than that, but it boils down to three separate aspects. Looking at the gravity of the offense. How serious is it? What's the nature of those circumstances? You look at Mr. Larry's character. Is there any criminal history? any special circumstances that would have impacted his decision-making, what transpired here. And public safety. I think that's pretty self-explanatory. The court looks to address all of those things in setting an appropriate sentence structure that balances those appropriately and does so in a manner that is no harsher than necessary. The court is always required first to look to probation to see if that can address any rehabilitative needs, if it makes sense to have someone out in the community to address some of those needs. No one's recommending that here. It's not available here for certain causes of action, and appropriately so, because that certainly would unduly depreciate the seriousness of these offenses and would not be appropriate in terms of public safety. But that's what we're looking at. We start with trying to be as lenient as possible, but factoring in all of these circumstances. I'm going to put into the record, the written record for this hearing. I know it's in the PSI, but looking at what the PSI writer had referenced in her summary based on her review and interactions with Mr. Larry. This is not something that I adopt wholeheartedly or even partially. But I think it's important. Attorney Tony has made his argument. Attorney Mogren, on behalf of Mr. Larry, has made his argument. Something else before the court is what DOC is recommending. And these are the summary of the reasons why. The agent states, Parise Larry is awaiting sentencing on multiple highly assaultive counts. Multiple persons were shot and had injuries. Victim 1 died. Parise Larry's actions placed everyone, including children, at risk. Multiple other children and adults were outside in the immediate area, including as he was running and shooting in the opposite direction without seeing where he was shooting. At no point is there evidence of the victims in this case acting aggressively toward him, including brandishing a firearm or harming him, until after his co-defendant fired a weapon at them repeatedly. Multiple people had damage to their apartments, vehicles, and injuries to themselves and family members. He has shown little insight as to the totality of his actions and decisions, including that multiple people were shot and victim 1 was killed. Multiple victims are still dealing with injuries and pain caused by Antonio Johnston. Victim 1's family will never be able to see them, speak with them, or touch them. Victim 1's mother stated Parise Larry, some of his family and associates have contacted Victim 1's family, laugh about Victim 1's death, caused issues when they see each other in the community, and while in court, and while they are concerned for the well-being of themselves and their family and the community as a whole. At no time did Parise Larry contact law enforcement or emergency personnel related to the victims in this case. He had multiple electronic videos and comments related to firearms, switches, and using them on persons, including shooting them in the head, and that victim 2 was going to die. From his initial interactions with investigators in this case, he has shown no remorse for his actions other than he is facing life in prison. While there is nothing that will change the injuries sustained due to his actions or bring victim 1 back to life, confinement time for Parise Larry will give them a sense that there is some justice for their loss, while ensuring the safety of the community against Parise Larry's utter disregard for the laws of the community, which are in place to help ensure safety. While he has made strides in obtaining his education, he has also engaged in assaultive, violent behaviors and sexually assaultive behaviors multiple times while in jail awaiting sentencing on this case. Parise Larry has shown a clear and utter disregard for the safety of members of the community. At no point did he attempt to get medical assistance for victim 1 or any of the other victims who were shot in the residential setting, which is very close to a school. He continued to fire the firearm while fleeing without regard to anyone's safety. He then put firearms and ammunition in an area on school property with no regard to safety, as they were accessible to anyone, including children, that attend school and events on the property. This crime is one of the most serious crimes one could commit, and a person is now dead. Confinement for life is appropriate given the crimes Parise Larry chose to commit. So that's the summary from the agent who conducted the pre-sentence investigation that served as the basis for the recommendation from that agent that the court went through toward the beginning of this hearing. She left off talking about the seriousness of this crime. I want to remind everyone that there's not just one crime that's before the court today. We have multiple separate counts, all of which is equally important. Obviously, what happened to Tatyanna Zech is the most serious. Her life was unnecessarily taken. There is not a crime that this court can think of that is more serious than that. It's not only a crime, it is a decision that completely sets aside any respect for another human being. But this isn't just about...
All right, hitting the pause button on this on this delivering of a sentence from the judge to bring in our guest who is standing by watching this. Criminal defense attorney and former prosecutor Marie Pereira is here. Marie, this judge is doing what we see most judges do for sentencing. They first lay out really the pros and cons, the prosecution's position, the defense's position, and we're going to get to ultimately what she is going to find for this defendant.
I see where she's going, because already she's talking about all of the aggravators that were highlighted by the person who conducted the interview. And it appears that he's getting in trouble even while in prison. It appears that people who support him are harassing the victims' families, which is a no-no. And it appears that he's showing remorse in court, but he's not showing remorse outside of court. And the fact that he's claiming his daddy's in prison, and then his lawyer said, we admit to drug use, and then he decides to go on a shooting spree, shooting backwards without even looking at who he's shooting at. And then it also says that the people he was shooting at, they didn't initiate the gunfire. It was his people and him who started doing all of that. So I see where the judge is going with it, and I think the judge is leaning towards giving him the maximum, a permanent sentence. You know why? Because that victim has a permanent sentence. That poor girl is dead, 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 never coming back. So I think he's going to get exactly what he deserves, in spite of the mitigators that his lawyers tried to put out there. He's got ADHD. He came from poverty. Well, a lot of people have ADHD and came from poverty, and their daddies are in prison. And they don't have to go around murdering people without a regard for human life. The judge is going to give it to him just like he deserves it.
Now, what about rehabilitation? Do you feel like his defense attorney spent enough time talking about the opportunity to rehabilitate? We know that's another one of the goals of a sentencing, and it's not saying that even if he gets parole, doesn't mean he's getting out in 40, 50, 60 years. It means a parole board will have to assess the same thing that this judge is weighing, how he's doing behind bars. Is he showing remorse when he comes before the parole board? Is there enough emphasis on that, or is it more just an explanation of why he may have committed these crimes?
You know, I think his attorney did what he could with the facts that the attorney has. And at the end of the day, he didn't do well during the interview. His history really doesn't give the judge a cause to say, let's not give him the maximum penalty under the law because there's chance for rehabilitation. I guess maybe I'm jaded, but to me, if it was a situation where he was simply with them and he didn't fire a gun, he was in the wrong place at the wrong time, I could understand. And the fact that they can't definitively put his bullet in that poor young woman's body doesn't mean he didn't shoot, because you see him shooting in his pink hoodie. That shuts it down for me. And I'm not a person that's saying rehabilitation should be never, never, but that girl's sentence is permanent. his sentence should be permanent too. Depending on the crime, I am not all about that rehabilitation. Once you kill somebody the way he did that, then rehabilitation, go ahead with that, but there has to be some justice for the victim's family.
Oh, they definitely are feeling what you are feeling and more. They have been inside of that courtroom, and we've even seen that ire kind of bubble up inside of the courtroom, no doubt wanting the stiffest penalty. We heard that through the victim impact statements. Marie, stand by. When we get to our break, we'll come back and give you more of the judge laying out the circumstances of this case as she's getting closer and closer to handing down her final sentence. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us as we follow this case against 16-year-old Parise Larry. He is close to finding out how much time he's going to spend behind bars for the murder of this woman, a 20-year-old woman, Tatyanna Zech, back in 2023 is when she was killed, caught in the crossfire of a shooting where Larry, the defendant, and his friend Antonio Johnston and another team who was visiting the victim. The two of these defendants, they were shooting at someone else, and they say that they were not intending to hit Tatyanna Zech, but she did end up fatally wounded. We want to get you back into the courtroom now. The judge still weighing the circumstances of this case before delivering her sentence.
Keyshawn Johnson was victim 2. There's a count of attempted first-degree intentional homicide as it relates to him being shot in these circumstances. The court sat through this trial. I'm aware of the facts and circumstances that this seems to have arisen and transpired due to some disagreements. I think the phrase beef was used at various points in time, perhaps even in the PSI, between Mr. Johnson and Mr. Larry. I'm aware of the videos that the live feed that Attorney Tony was referencing earlier of Mr. Larry making some threats as it related to Keyshawn Johnson. Threats involving guns. Let's go pipe for pipe. Threatening to kill Mr. Johnson. I'm aware that Mr. Johnson did fire back in those circumstances. I think he got off one round, is what the evidence supported. I'm also aware Mr. Larry, it did not appear, fired first. That was his co-defendant, Mr. Johnston. This case is also about Javier Rosario Rodriguez, a gentleman who comes back from Quick Trip. I think he got a coffee for his wife, if I'm remembering correctly from the PSI. Asleep in his bed, gets shot in the back. It's an injury that stays with him to today. If anyone was here in the courtroom and watched Mr. Rosario Rodriguez take the stand, he had a visible, difficult time walking. That's something he has to live with. He referenced in his victim statement, and it was referenced in the PSI, that his wife was unable to work. She had to care for him. They had to continue to reside in the bullet hole-ridden apartment in which he was shot due to financial circumstances. The case is also about his son, Emmanuel Rosario Santos, who also had a bullet come in. He escaped more significant injuries by just having that bullet graze him. I believe it was an injury to his knee. It's also about victim 4, Michaela Stewart Boyd. Victim 6, D. Ray Brown. Victim 7, Namarian Stewart. All individuals who accompanied Ms. Zech, Keyshawn Johnson, while taking out the garbage, walking back before these circumstances took place. So in looking at the gravity of the charges, it's a plethora of some of the most serious charges anyone could be facing. Not only did people die, or a person died, multiple people were injured, multiple people were put at risk of losing their life or otherwise being seriously injured. Attorney Tony referenced.
In this case, you can just see it on the judge's face. This seems to be one that she's struggling with, and she's even aired or talked about her frustration with the gallery, but you almost see that it's a frustration with everything that she's having to deliberate over. Essentially, she is the one who's going to be handing this down. We don't have a jury that is going to be deciding a sentence, so it all rests on what this judge says. And it's something that could be appealed ultimately, so that's why we have judges laying out all of the details as to what goes into their sentence. Let's go back in.
There is no doubt that the science referenced by Attorney Mogren is accurate. It matches with common sense. Anybody who may have a child, you recognize that that child's brain continues to evolve, to develop as time passes, as they gain more experience. So as Mr. Larry sits here, I have no doubt that he is continuing to learn, and his brain is continuing to develop, and he may very well be a different person 5 years from now. I think generally speaking, the research tends to show till about age 25. And even then, obviously, we all continue to learn from those experiences. So he's young. He has educational difficulties, as noted by the IEP and the ADHD. He does not have any criminal history. He does not have any juvenile history. I think there were some references to some citations, getting in some trouble at school, but nothing else that would show a pattern of this type of behavior. While that history is lacking, what's not is some of the evidence of behavior that he engaged in prior to the circumstances of May 7th. There was reference to in the PSI. I think Attorney Tony hit on some of that today during the trial and the reverse waiver hearing. Mr. Larry had a significant number of concerning social media posts. Posts that involved a large amount of guns, some with extended magazines. The video that was played, that live feed, as I've already referenced, you hear him make threats to Mr. Johnson, and you hear him talk about going pipe for pipe. Even in the PSI, he acknowledges and talks about how his dad is his twin, I think to his dad's dismay. The PSI referenced that his dad did not want that life for Mr. Larry and tried to discourage any type of gang-banging activity. It's not my phrase, it's the phrase used in the PSI. But it references statements from Mr. Larry indicating he believed that life to be glamorous. Just pulling that out so that I don't misspeak. He felt he got to know his father and said, "That is my twin right now." He would look up to his father and cousins and always saw himself getting into those things. He was able to provide an example of him throwing...
We have to step aside for a break. The judge saying that he may very well be a different person in several years, because remember, this guy is 16 years old inside of that courtroom, 14 years old when this happened. We do have this programming note before we get to the break. This is coming up tonight. The Reiner Family Murders, a Court TV special. It's going to be airing at 8 p.m. Eastern. Our own Court TV lead anchor, Vinny Politan, is going to take us inside of the investigation and the charges against Nick Reiner, as field reporter Cody Thomas is there live in Los Angeles. They'll be breaking this down in a unique way, everything that has transpired over the last 7 days. Be sure to keep it right here on Court TV at 8 p.m. You do not want to miss it. And when we come back, the judge is going to issue her sentence for Parise Larry, when we come back. Stay with us.
A brutal killing sends shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation
Their own son charged with their murders.
as a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
We want to get you back to Wisconsin, where the judge is now sentencing Parise Larry in the Caught in the Crossfire trial.
As it relates to, I'm gonna do, I think what the state did as far as the structure, and starting with count 17 makes sense. So as it relates to count 17, that's the possession of a dangerous weapon by a person under the age of 18. The court is going to order 9 months jail. And that sentence will be concurrent to any other sentence. As it relates to counts 12, 14, 15, and 16. The court's going to adopt the state's recommendation and order 10 years of initial confinement, followed by 5 years of extended supervision. Count 12, 14, 15, and 16 will be consecutive to each other. And the reason that that's running consecutive, and I'm going to have a few other things run consecutive, is the reason that frankly was articulated by Attorney Tony. The court believes that it's important that each individual crime here that had a separate victim, separate wrongs done unto them, be addressed in a separate manner. And I think that's necessary given the seriousness of all of these offenses. Because while what happened to Ms. Zech is certainly the most significant among all of these charges, it does not diminish what happened to victims 2, 3, 4, 5, 6, and 7. As it relates to count 11, the court's going to order 20 years of initial confinement, followed by 10 years of extended supervision, consecutive to any other sentence. As it relates to count 10, the attempted first-degree intentional homicide, the court's going to order 40 years of initial confinement, 20 years of extended supervision. That's going to be concurrent to any other sentence. And as to count 9, the court is going to order life imprisonment without the possibility of extended supervision. And that will run The other counts that the court identified consecutive to each other, all of them will run concurrent to count 9. There is stipulated restitution that the court's going to order. That's $7,321.89 in restitution owed on behalf of victim 1. $1,200 in restitution on behalf of victim 2. As additional conditions of any term of extended supervision, the court would order that Mr. Larry maintain absolute sobriety, that he not use or possess any controlled substances without a valid prescription, that he have no contact with co-defendant Antonio Johnston, no contact with the victims or the victims' families, and any other treatment or counseling per his agent. He will need to provide a DNA sample and pay the surcharge that accompanies that, as well as court costs. I do find that the sentence set forth by the court today is the minimum amount necessary to satisfy those sentencing objectives that I identified earlier. As it relates to programming, the court denies eligibility for both CIP and SAP, not only due to the statutory ineligibility as it relates to some counts, but also as a result of the seriousness of the offenses before the court. Attorney Mogren, do you have a calculation on jail credit owed to Mr. Larry?
I don't. I can provide one to the court shortly.
All right. If you inquire of the jail, they have a sheet they can forward up. I will take note of that. If I don't receive an objection upon receipt of that within 5 days sufficient, Attorney Tony?
Yes, Your Honor.
The court will look and address credit accordingly.
And Your Honor, I think the court mentioned at the beginning the restitution I think would be joint and several.
Yep. That is going to be what the JOC will reflect. I am going to order any restitution to be joint and several, with the caveat that I don't yet know how that will come in for Mr. Johnston. But any restitution ordered is joint and several. Now, because Mr. Larry, as a reminder, has been convicted of felonies, it would be a crime for him to possess a firearm. That crime would be punishable by a fine up to 10 years of imprisonment or $25,000 in fines, or both. He also is not able to vote in any election until those civil rights would be restored to him. We're also dealing with violent felonies. So it would be a crime punishable by a fine up to $50,000 and 15 years of imprisonment, or both, for him to possess body armor. The statute does require that the court advise Mr. Larry.
All right, she's going to get into those fines and other smaller details, but the breaking news is that this defendant is getting life in prison without the possibility of extended supervision, and those other charges are going to run either concurrent or consecutive to that. We also mentioned that Parise Larry's co-defendant, Antonio Johnson, was also convicted of first-degree intentional homicide. His sentencing actually happened after Larry's in real time, and the judge also gave him life in prison without the possibility of parole. Let's bring back in criminal defense attorney and former prosecutor Marie Pereira. Marie, you called it. You said that the judge was not going to show any mercy to this teen, this 16-year-old who was tried as an adult.
I'm not surprised. And I also like the fact that she separated each and every victim. I don't like it when a crime happens and several people are murdered or hurt or impacted, and then because it's a big sentence, they make it run concurrent. It should be consecutive because the pain is consecutive. And I like the way she described each and every person and how they were impacted, even though they're still alive. The man who was basically sleeping in his bed and got shot. I didn't even know about all those details. So I was even more upset about that. I tried to take note of how many years, but I don't do long division or long addition. I'm math challenged. But all I know is he's never seeing the light of day again, just like the poor victim who was killed, murdered, will never see the light of day. Let him capture that energy. Sorry, sir.
Yeah, you mentioned those other victims. The judge even at one point talked about the kid that we see in the surveillance video on the scooter who was getting away, that child was put in danger and saw violence essentially as they were getting away. So she included that in her sentencing recommendation, just thinking about what that child had to go through. This family, they were wearing sweatshirts, Marie, in the gallery that had the victim on it, a memorial for her. The judge did say you need to take that off. I understand why you're wearing it. It's not going to influence my decision. But just your thoughts about what they are feeling after a very emotionally charged sentencing hearing today.
To use the word aggravated, upset is not even a word. That little girl is gone, and everybody who got shot has to live with those injuries and the fear and the trauma that brings upon somebody's life. And then to have any members of his family outside trying to control the situation, coming and asking for mercy. Listen, the law is the law. I'm glad that the judge really kept it tight and gave him every year he deserved for what he did. And again, I'm not against rehab, but when you look at the totality of the circumstances and his lack of remorse and the way his family's outside, again, trying to hurt the victim's family, putting them in a position where they don't feel safe, he deserved everything he got. In this situation, rehabilitation was not on the table as far as I'm concerned.
And there you have it. That is the finality right now for Parise Larry. No doubt his attorneys are going to be filing an appeal on this one, especially with the factor of his